Right, we're going to have a look at the Employment Relations Authority process and investigation meeting and what happens. Now, in terms of the process, where we are is that after having sent letters to the employer and then filed in the authority, if we've had to then get to mediation, several months have gone by, and then we assist you in writing a witness statement for you, and you participate in providing us with the information and documents. We help you write that up and we file it. And then we have the day of the investigation meeting. It's about probably at the moment with the ERA backlog, it can take 12 months to get there. And then after that meeting and submissions are given, then the authority has 3 months to make a written decision. So, on our website, we've got Employment Relations Authority investigation and some videos. There's 5 of them. Now, these were originally created by the Victoria University of Wellington, and it was on their YouTube channel. But recently I found, and having linked to them, that they've made those videos private. So I, a couple of years ago, actually downloaded them for this day, so I've actually uploaded them to our own channel. So thanks very much to the efforts of Victoria University and the actors in these series of videos, and former authority member Tanya Tatitata. So let's start by looking at the introduction, and as we go I will pause and commentate where necessary.
Hello, my name is Tanya Tatitata and I'm the member from the Employment Relations Authority presiding on this case today. Now, this is an application brought by Mr. Pink alleging unjustified dismissal by Ms. Cabot. Now, to get things started, can each of the parties please introduce themselves and tell me what your particular role is today? Let's start with Mr. Pink.
Hello, my name is Mr. Ken Pink and I'm the applicant.
Thank you.
Hello, my name is Linka. I'm the representative for Mr. Pink today.
Hello, my name is Miss Eddie Cabo and I'm the respondent.
My name is Mike and I represent Ms. Cabo today.
Hello, I'm Linda and I'm here to support Ken Pink today.
Right, thank you and nice to meet you. All right. Now, from the documents I've received, I understand the issue we're dealing with today is whether Mr. Pink was unjustifiably dismissed and whether he's entitled to an award of remedies. Now, can I first check with Mr. Pink what remedies you're asking for today? I understand you're asking for 3 months' wages and damages for, or compensation for hurt and humiliation you've experienced of around $5,000, is that right?
Yes, that's correct.
The other issue I understand from the evidence is whether Mr. Pink contributed in a blameworthy way to the circumstances leading to his dismissal. In other words, did you do something which caused the personal grievance to occur? So the issues, in summary, that we're dealing with today is A, whether Ms. Cabo's actions in dismissing Mr. Pink were what a fair and reasonable employer could have done in all the circumstances. B, if I find that's not the case, whether Mr. Pink has taken reasonable steps to mitigate any losses consequent to his dismissal. What I mean there is whether you've got another job within the claim period and what wages you earned. And C, in relation to the remedies sought, whether Mr. Pink has contributed in any way. Now, this matter's been allocated 3 hours hearing time today, and we should have sufficient time to finish this matter, but if not, a little bit more time can be allocated. We'll take breaks as we need them. Now, I've read the witness statements and documents which have been filed, and they'll form the basis of our discussions today. If there's anything you want to add to your witness statement, you can do so either prior to or during the questioning. But in terms of the program for the hearing, firstly I'll start questioning the witnesses, then I'll allow the parties to question the witnesses. Then I'll consider what you've said to me and I will give a decision thereafter. Now let's start with the order of witnesses. Is there any particular order the parties require? No? Okay, then we'll go with the normal order with the applicant who's bringing the case. Then I'll move across to the employer, Ms. Cabo, who's responding to tell us why the remedy sought should or shouldn't be granted. Any problems with that order? No? Okay, well let's start with Mr. Pink and we'll finish with Ms. Cabot.
Great. Okay, so the sort of legal framework that we're looking at is the Employment Relations Act 2000, and the member has referred to what this case is about. It's a claim for unjustified dismissal, and that claim under the Act, under Section 103, Personal Grievance 1A, is that the employee has been unjustifiably dismissed, and then she referred to Section 103A, which is a test of justification. So the employer is required to demonstrate justification on inquiry by the authority or the employment court, and that the question is whether the dismissal or action was justifiable. It must be determined on an objective basis and applying the test in subsection 2, and also that the test involves whether the employer's actions and how the employer acted were what a fair and reasonable employer could have done in all of the circumstances at the time of the dismissal or action occurred. Now, these things in subsection 2 are prescriptive tests that involve natural justice, like whether having the resources available to the employer, that it's officially investigated the allegations against the employee before dismissing or taking action, and whether or not those concerns were raised with that employee, and whether the employer gave the employee a reasonable opportunity to respond to those concerns, and then whether the employer genuinely considered their explanation, and the authority or the court can consider other factors it thinks appropriate that are relevant, and a action or dismissal by an employer, the authority or court must not determine a dismissal or action to be unjustifiable solely because of defects in the process followed by the employer if those defects were minor and did not result in the employee being treated unfairly. So there is a level to reach for procedural unfairness. The member also referred to remedies sought by the applicant. So we're looking at remedies in relation to personal grievances 1, 2, 3 of the Act, and so what Mr. Pink is seeking is 3 months for lost wages, so that's 123(1)(b), reimbursement to the employee of a sum equal the whole or any part of wages or other money lost by the employee as a result of the grievance. And he's also looking for hurt and humiliation, loss of dignity and injury to feelings as well. Things like KiwiSaver or bonuses or other monetary things can be claimed under this 1B, which is other money lost. Now the member also referred to considering contributions, so section 124. So where the authority or court determines that there has been a personal grievance, then the institutions must, in deciding the nature and extent of the remedies to be provided in respect of the personal grievance, they need to consider the extent of which the actions of the employee contributed towards the situation that gave rise to the personal grievance. So blameworthy conduct, like swearing, violence, drugs, anything that is blameworthy, there's a consideration for reducing remedies. So the member also talked about the order of witnesses, so and also how questions are going to get asked. The different authority members will do different things. For example, Rob and Arthur will quite often hear from the employer first, where the employer has the onus of demonstrating justification, and so often their evidence is heard first, depending on the member you get. Most of the time though, it's the applicant that has to give their evidence first. Now at this point, as I've referred to already, there is witness statements and documents filed, and so you can expect to participate in producing probably up to between 5 to 20 pages of numbered paragraphs explaining what happened in terms of your dismissal or unjustifiable action, and also explaining how it affected you and what your losses were, and that document, that witness statement, refers to other documents which are either attached to it or in a common bundle, and they're page numbered and referred to. So it can be quite a lot of work to produce that. Up until we get to this point, it can be days of us assisting you writing your statement. It's quite a lot of work, and the thing about this that I don't like is that we have to put in the evidence first, and the employer they just sit back, relax, and they don't have to really do anything. So for the employee, we're having to do all the work first. But once we do that, then it's their turn, and then they can bowl. Right, let's have a look at employee evidence now.
Okay, Mr. Pink, you have two options. One, you may either take an oath on the Bible or an affirmation. What would you prefer?
Affirmation, please.
Okay, could I ask you to raise your right hand, please? Do you solemnly and sincerely affirm that the evidence you shall give touching on the matters now before the authority shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Now, I have a copy of the brief you filed in front of me. You've got a copy as well in front of you. Have you read through it?
I have.
Are there any changes or corrections to make to your brief?
No.
So everything in there is true and correct to the best of your knowledge and belief. It's still the evidence you wish to give to me today.
Yes.
Okay. Thank you. That's now sworn evidence and it'll come in on the record. So you're 40 years old, is that right?
Yes.
Okay. And you're a solo dad, I see.
Yes.
How many children have you got?
I've got 3, 2, 5 and 9.
So at the time of your dismissal, you were working for a Ms. Edie Cabot, is that right?
Yes, I just started work on a shop fit out. It was for a new diamond store.
And when did you start working for Ms. Cabot?
17th of June 2013.
Now, in the statement of problem, you say on the first day you worked for Ms. Cabot, she spoke to you in the afternoon. Can you tell me what you talked about?
Miss Cabot came to me and said that she wanted to speak to me. She took me outside. She said some diamonds were missing from the store. She said that someone had seen me take them. She asked me what I had to say to that. I told her that I'd been with Winston White. He's a workmate of mine.
And what did Ms. Cabot say to you about that?
She told me to take my stuff and go. She said, just get out.
She just told you to leave, did she?
She said something about not being able to trust me anymore.
So she told you she couldn't trust you anymore. Did you understand what she meant by that?
No.
Did she give you an opportunity to speak to her further about that?
No, she just told me to go.
So you didn't tell her what you thought about the allegation she couldn't trust you?
No, she didn't give me any chance, and to be honest, I was too upset about it to really say much. Anyway.
Did you know that her concern was about some missing diamonds?
She said someone had seen me take them.
Did she tell you who that person was?
No.
Did you tell her you didn't take them?
I didn't say it in so many words because I was really upset and shocked, but I said that I'd been with Winston all the time.
Had you worked for Ms. Cabot before?
No, that was my first day.
Now, in your brief of evidence, you say you signed an employment agreement, but you didn't have a copy of it. I understand Ms. Cabot has a copy of your agreement and you've seen it, is that right?
Yes.
And is this copy like the one you signed?
Yes, it looks like it.
Now, you've got your own copy there of the employment agreement. I just want you to have a look at clause 24. Now, that clause of your employment agreement lists theft as an instance of serious misconduct, the penalty for which may be dismissal. Can you see that?
Yes.
Now, were the terms of your employment agreement referred to in your meeting with Ms. Cabot?
No.
Tell me what you've done since your dismissal work-wise.
I've tried to get some jobs, but I haven't managed to get any yet.
Have you got any evidence of those jobs that you applied for?
No, not with me.
So this is why, in every case that I deal with, in the first conversation with our client, I say to them, and quite often they've just been fired, or maybe a couple of weeks have gone by, whatever. You need to document your job searching evidence. And so the best way to do that is have a diary or a piece of A4 paper, and every time you apply for a job, write down the date, the time, what job you applied for, what company was it, and the role that you're applying for. And when you go and have a job interview for any of these, also make a log entry about when you went, who you spoke to. Log all of it, because that's got to be in your witness statement. The legal principle that the member is concerned here with this right now is whether or not Mr. Pink has gone to reasonable efforts to mitigate his losses. And mitigate basically means reduce the damage to himself. So he needs to work to improve his situation and apply for jobs. And there's going to be, if he gets another job, then in the 3-month claim period, which is the first claim period under the law, under Section 128 of the Act, he might find a job within, say, 2 months. But if he can show that he's made several, if not 10 or 20 job applications, he'll get awarded lost wages if he's successful with his grievance. And that's calculated based on the weeks that he would have otherwise earned that money had he not been fired. But yeah, effectively, if he doesn't do that, then he could just be sitting on the couch all day long watching Days of Our Lives in Chorlton Street during the day, or whatever they play now, and not lifting a finger. It's the duty of a plaintiff to mitigate their losses is a common law doctrine, and it's not specifically written in the Employment Relations Act, but it is a legal doctrine that gets applied, and it gets applied here too. Carry on.
Let's go back to the events immediately before your dismissal. What did you think Ms. Cabot was coming to see you about during the smoko break?
I didn't know until she started to talk to me.
And when she started to talk to you, what did you think?
It doesn't sound good. She said that there were some diamonds missing, and yeah, it didn't sound good.
Was there anyone else around at the time?
Yeah, the rest of the group was there.
Could they hear?
Yes.
Did Ms. Cabot walk away with you to have this conversation?
Yes, she took me outside.
And could the others hear you at that point?
No.
Before your dismissal, were you given a chance to have a representative present?
No.
Before your dismissal, did Ms. Cabot warn you dismissal might be an outcome of this process?
No.
In her statement, Ms. Cabot noted that you left for 15 minutes before the smoko. Can you talk me through why you left and where you went?
I went to get a can of V.
Where'd you get your can of V?
Oh, down the road, down the shop.
Okay, all right, well, thank you. If you could just remain there, Ms. Cabot's representative may have some more questions for you.
Okay.
Right, so the authority's procedure is often, because the authority is an inquisitorial body, that they, as the decision maker, they ask their questions of each witness first before there's cross-examination. This can differ. Different members like to do different things. This is kind of because what's about to happen is that there's going to be cross-examination by the advocate for the employer, cross-examination of the employee, the applicant. But quite often now what I'm finding is that the authority will actually let me ask questions of my client immediately after the authority has asked questions. So yeah, it really, again, and as I've talked about, it depends on which member you get on the day. So we'll carry on.
You say in your evidence that you were with Mr. White at the site all through the day. However, you've just said to the member in reply to her question that you left the site to go down the road to buy a can of V. Was Mr. White with you at that time?
No, he wasn't.
Were there other times you left Mr. White during the day?
No, only at that time.
Okay. So when you told Ms. Cabot you were with Mr. White all day, that was wrong, wasn't it?
Yes.
Thank you. Nothing
Righto.
more.
Okay.
Right, thank you. Are there any questions in re-examination from Mr. Pink's representative? Right, thank
So
you.
re-examination is where after cross-examination, so cross-examination, closed questions can be asked, and it appears that this advocate asked open questions, but when the if there's any damage done, and we did see damage done there a little bit, it's not really that significant, but Mr. Pink says that he had his colleague with him all day, but then when he went down the road to get a can of V, it's been established that this other person was not with him at that time. So any questions that are asked and answered in cross-examination, then the advocate for the applicant can ask re-examination questions. So now this lady's given the opportunity to do so. From memory, I don't think she really had anything for him, but at this time with re-examination, or if you're questioning your own witness, then you must not put the answer in the question or ask leading questions or closed questions. They must be open. We'll see some examples of that a bit later if we don't see some now. So we'll move on to the employer evidence.
Ms. Cabot, the procedures now that I've got to require you to take an oath or an affirmation, you have those two options. You can swear on the Bible or you can take an affirmation. Which would you prefer?
Bible, please.
Can you please place your right hand on the Bible? Do you swear by Almighty God that the evidence you shall give touching upon these matters now before the authority shall be the truth, the whole truth, and nothing but the truth?
I do.
Right, thank you. Now, Ms. Cabot, you filed a brief of evidence, is that right?
Yes.
You've got that in front of you?
Yes.
You read through it?
Yes.
Are there any changes or corrections you need to make to it?
Yes, I do have something I'd like to add.
All right, I'll ask your representative to lead that new evidence.
Why?
So that's an interesting example that's about to play out about leading your own witness. And so, as I've been talking about, when a representative asks their witness questions, they must be open, not closed cross-examination style questions. And this evidence being given right now is now before the authority member is actually asking their questions. Obviously there's been a request or there's been a memorandum filed to ask for this as to a circumstance that has arisen. So the authority member is allowing the advocate for the respondent to ask some questions. So we'll just have a look at what happens here.
Have you not called Mr. White to give evidence today?
Unfortunately, he died shortly after Mr. Pink's dismissal.
And tell me, were the diamonds ever found?
Yes, they were found in a toilet cistern in the bathroom.
Thank you.
Ms. Cabot, did you speak to Mr. White on the day the diamonds were stolen?
Yes.
And did he indicate he'd worked with Mr. Pink for the entire day with the exception of a 15-minute period?
Yes.
Did you see Mr. Pink leave the premises that day?
No.
Did you speak to Mr. Pink about what Mr. White had said?
No, I didn't.
Did you ask Mr. White what he was doing in the toilet?
No.
Can you explain why you dismissed Mr. Pink without any further questioning of either him or Mr. White?
Well, I thought I'd done enough. I mean, he lied to me about his whereabouts and he'd only been on the job one day.
So is it correct that you spoke to Mr. Pink about the diamonds on the day of the incident after you'd spoken to Mr. White about him leaving the premises?
Yes, I did.
Did you tell him you thought he'd taken the diamonds?
Yes.
And how did he respond?
He didn't.
So why didn't you give him some time to think about your allegation that he may have taken the diamonds?
Well, I did, but he didn't respond. He just went red and said nothing else.
Did you ask Mr. Pink if he wanted a support person or a legal representative present?
No, as I said, he'd only been on the job a day.
Before you made this decision to dismiss, did you tell him that might be the outcome of the process?
Well, I thought that would have been obvious.
Right, thank you, Ms. Cabot. I've no.
Yeah, so I mean, that's really just not good enough. You know, the employer here hasn't demonstrated that they had a sufficient and reliable evidential basis to reasonably conclude that serious misconduct occurred, that Mr. Pink had stolen diamonds. I mean, this employer did not set up a meeting to meet with him, to provide him with the information beforehand or during a meeting as to the allegation, and that if diamonds are found in the toilet cistern, and that, you know, you're accused of stealing the diamonds, and the right to bring a representative or a support person. And I mean, representative or support person, I mean, it's not really a major defect. I think that really it's more, the law is really about, you know, did the employer have a sufficient and reliable evidential basis to reasonably conclude their finding. And this employer hasn't followed any process whatsoever to reasonably conclude anything. They didn't really ask anything of the employee or present them with the tentative conclusions before making this decision to terminate his employment in the way they did. Carry on.
No further questions. I'll invite the applicant's representative to ask any questions.
This is cross-examination of the
Thank you. Ms. Cabot, you said before in your evidence that you saw Mr. White leave the toilets.
Yes.
And you also said that the diamonds were found in the toilets.
Yes.
Did you at any time see Mr. Pink leave the toilets?
No, I didn't see him.
I'll refer you to your evidence where you stated that anyone who took the diamonds would have had blue stained hands.
Yes.
At any time did you examine Mr. White's hands?
No.
At any time did you examine Mr. Pink's hands?
No.
I have no further questions for Ms. Cabot.
Thank you. Mike, do you have any questions in re-examination?
Nothing further, thanks.
Right, well, thank you both parties. So we'll take a short break of about 45 minutes, then I'll hear from both of you with your closing submissions.
So after the evidence is heard, then the authority member will want to hear submissions, and quite often we're not given 45 minutes. It has to be almost straight away. You're lucky if you get they might take a 15-minute break. So when we have closing submissions, when I go to these investigation meetings, I've already written it up. And quite often it's about 25 pages long of how and why we should win, and what the quantification is of the losses for the hurt and humiliation, and for the lost wages or any other monetary benefit that was lost. So that is often, we write as I said, a written document, and then we speak to those submissions. So let's have a look at closing submissions here. This is what it really looks like.
Okay, thank you all. Now you will have your opportunity to sum up your evidence and tell me your closing arguments in support of your respective parties' cases. The applicant is to go first, followed by the respondent, and then I'll give a short right of reply to the applicant to whatever the respondent has told me. So we'll start firstly with Mr. Pink's representative, Lincoln.
Yeah, so, and the right of reply is after we go, then they go, and then we can reply, because quite often what they say is a lot of bullshit, and so we get an opportunity to rebut any points that are required. So let's have a look.
Thank you. So starting with the key facts, I think it has been established before the authority that Mr. Pink was employed as a labourer by Ms. Cabot starting on the 17th of June 2013 to work. On the day in question, on the 17th of June 2013, he was approached by Ms. Cabot when he was with his colleagues at a smoko. Ms. Cabot understood that at that time the diamonds had been stolen. She then pulled Mr. Pink away from his colleagues to his distress and had a private meeting with him, stating that he had stolen the diamonds and that he had to go. At no point did Mr. Pink have an opportunity to respond to those allegations, and what was also clear from the evidence we heard from Ms. Capo is that she did no further investigation beyond speaking to Mr. White. What we also heard today was that Mr. White himself had also been in the toilet where the diamonds were found, and that neither Mr. Pink nor Mr. White had had their hands examined to see if there was any security dye on their hands. That raises the questions as to whether an adequate investigation was really carried out. As a result of this, we believe that a fair and reasonable process hasn't been followed in terms of Section 103A of the Employment Relations Act 2000, and Mr. Pink was unjustifiably dismissed because in particular there was an insufficient investigation of the allegation by Ms. Cabot, and there was no reasonable opportunity for Mr. Pink to respond. I think it is quite clear that her actions caused significant humiliation to Mr. Pink in front of his colleagues, and also taking into account Mr. Pink's personal situation, as stated in his evidence before the authority, that he is a single father who has been without an income for a long time as a consequence of Ms. Cabot's unjustified dismissal. Turning to the respondent's evidence, she said that she did not trust Mr. Pink and she could dismiss him. However, there was no reasonable basis for that mistrust apparent on the evidence. She did not examine the hands. She did not see Mr. Pink come out of the toilet himself, where the diamonds were found, and he was not allowed an opportunity to respond to the allegations. As a result, I submit there is a strong case here for asking unpaid wages for 3 months for Mr. Pink's dismissal and for a payment of a sum of $5,000 for his humiliation.
She should have asked for more for the humiliation.
Thank you. Mike, can you present your closing submission?
Yes, in summary, the key facts are Mr. Pink signed an employment agreement and was dismissed on 17 June 2013. On the same day, someone stole some diamonds. Ms. Cabot asked Mr. Pink about it. She took him outside and asked him what he knew about the diamonds, and he failed to use that opportunity to respond. In terms of the evidence presented today, Mr. Pink said he was confronted about the issue in front of his colleagues. He was in fact taken aside and her concerns were put to him in private. In terms of the allegation, Ms. Cabot clearly put her concerns to Mr. Pink. He had an opportunity to respond to those and he failed to do so. We also heard inconsistencies in Mr. Pink's evidence. He told Ms. Cabot he was in Mr. White's presence all of the day, and today he told the authority he was apart for 15 minutes, in which he alleges he was at a supermarket getting a can of tea.
I like this guy.
There is no evidence to support that. He also confirmed here today he was in the bathroom where the diamonds were later found. I submit there is a question as to how honest Mr. Pink has been with Ms. Cabot in
But
terms
as I've
of
said,
what he was
sufficient and
in fact
reliable
doing.
evidential basis is not here.
I submit Mr. Pink was given a fair chance to respond to Ms. Cabot's concerns and he failed to take that chance. In terms of humiliation, I submit there was no humiliation, and if there was, it is something he brought upon himself in not participating in the discussion
Well,
fully
that's bullshit.
Ms. Cabot. I finally submit that Mr. Pink was justifiably dismissed. And note, in relation to the claim for lost wages, There is no evidence that Mr Pink has made a reasonable effort
I agree
to
with
find
that.
another job. And there's no shortage of labouring jobs.
Like I said, we tell all our clients.
Thank you
apply
for your
for
closing
jobs
remarks.
and,
You now have a right to respond, Bianca.
Thank you. There is no evidence to support that the respondents claim that there are plenty of labouring jobs at the moment. Thank you.
Thank you. Thank you both for your closing submissions. I'll take a short recess and we'll come back and do my decision.
Brilliant. So, the decision, now, it used to be that the authority the members would make a oral determination on the day, or at least give an indication of where they see the cases going on the day. I haven't seen that happen for years. And it's unfortunate we end up having to wait at least 3 months, quite often on the actual final day of that 3 months. Then there's a written determination filed and it comes to my email inbox, and then I remember that case, alright, what was the result? And there can be sometimes spelling errors, grammatical errors, or legal errors. But this is how it used to be. And it's a shame that it's not like this now. Oral determination.
Mr Pink was employed for one day in a labouring job outfitting a diamond store. Ms Cabot dismissed him for stealing diamonds. He challenges his dismissal and seeks lost wages and compensation for hurt and humiliation and injury to feeling. The issues for me to decide are: one, was Ms Cabot's decision to dismiss Mr Pink one a fair and reasonable employer could have done in all the circumstances? If not, whether Mr Pink is entitled to his claim for lost remuneration. And thirdly, whether Mr Pink contributed in a blameworthy way to the circumstances leading to his dismissal. Now, the law is well known. An employer must investigate concerns, raise those concerns with the employee, give the employee a reasonable opportunity to respond to the concerns, and then genuinely consider those concerns or that explanation prior to dismissal. Now, Ms Cabot tells me the dismissal was justified because she gave Mr Pink a fair chance to comment on the allegation, and he failed to provide one. Now, any procedural deficiency, she tells me, in this dismissal process should be balanced against the fact he was only employed for one day. Now, I find Mr Pink was unjustifiably dismissed. I don't accept Ms Cabot's arguments, and I explain that in the following way. I find the investigation was inadequate. Ms Cabot failed to investigate key issues which were relevant to the allegation of theft, and of which she was quite well aware of before she reached the decision to dismiss. And these, of course, included Mr Pink and Mr White's hands being stained or not stained, and who they'd been in the toilets with and when. I also find the allegation was not fairly put to Mr Pink, which denied him a reasonable opportunity to respond. Now, he was not told he could consult a representative or that a possible outcome of this process may be, in fact, dismissal. Those elements are fundamental to the obligations of a fair process. The duration of employment is irrelevant. Ms Cabot had an obligation to act as a fair and reasonable employer prior to making any decision to dismiss. The allegation of theft is a serious one. It requires an employer to do more than what occurred in these particular circumstances. Ms Cabot had the resources and time to ask more questions. She failed to do so. I now turn to Mr Pink's claim for remedies. Mr Pink is required to take steps to mitigate his losses. This includes reasonable efforts at finding alternative work. I'm not satisfied he has taken reasonable steps to mitigate his lost wages. I accept he's been out of work for 3 months,
So when I
but
ask you
without
to,
adequate evidence
apply
of
for
steps
jobs
he's
and,
taken to find another job,
document those efforts
he has not
in your
made out
diary,
his claim.
You gotta do it.
I am, however, satisfied Mr. Pink was humiliated and hurt by this dismissal. I find that deficiencies in the dismissal process would have compounded those feelings, and I award him $5,000. There is an order pursuant to section 1231CI of the Employment Relations Act 2000 that Mr. Cabot paid to Mr. Pink, that Ms. Cabot rather, paid to Mr. Pink the sum of $5,000.
123.1CI. Are you kidding? Section 123.1C, Roman numerals 1, 2. She calls that I. I've heard this happen, especially Ministry of Business, Innovation and Employment mediators say this as well. And oh man, you know, look, a 12-year-old could look at this and tell you that they're Roman numerals. It's not an I.
I also find that there was no contributory conduct requiring a reduction in either remedies. Thank you.
Great. So that's it. That's what happens. So thanks for watching. We'll see you next time.